Welcome everybody. This is the podcast Diritto al Digitale, where we explore the intersection between innovation and law. I'm Giulio Coraggio, your host, a data and technology lawyer at the global law firm DLA Piper. And today I'm delighted to have as guest of our podcast my colleague, our senior lawyer, Valentina Mazza, one of our most prominent IP lawyers of our Italian team, and we will explore the intersection between intellectual property and artificial intelligence, obviously. Welcome, Valentina. And today we talk about a very important decision by the Delaware courts on the usage of fair use, or the fair use exemption in relation to artificial intelligence. Can you just give us a bit of background of what the case is about and why it's so important?
Thanks for the introduction, Giulio. Hello, everyone. I'm glad to be here today to discuss this landmark decision, which is one of the first cases being decided on the issue of fair use when it comes to the use of copyrighted materials for the training of AI tool. But let's start from the beginning. So the case was brought by Thomson Reuters, which is the provider of Westlaw, a well-known legal research tool, which is used in the US and gives paid access to case law, statutes, law journals, editorial contents, and even head notes, which are basically summaries of the most relevant and recent legal decisions. So on the other side, we had Ross Intelligence, which is basically a competitor aiming at introducing on the US market a similar tool, so a legal search engine. And he was actually planning to train this engine with the AI. So what happened here is that Ross sought a license from Westlaw to use the head notes for the trainings, but Westlaw denied the license. So after that, Ross made a deal with another provider, which is called Legalese, which actually gave data which were called bulk memos. And those bulk memos are, again, notes which are drafted by lawyers about legal questions and which provide positive and negative answers to that issues. Mm-hmm. The fact was that such bulk memos were built based on the head notes of Westlaw, so something which indeed Ross tried to access but was denied.
So basically, Ross was upset because he didn't get the license, and he found a way of
to circumvent, exactly, the denial of the license. And of course, when Thomson Reuters found that out, it sued Ross for copyright infringement. So as you said, here the key issue is whether such use by Ross without the copyright owner's consent, so without Westlaw's consent, of such copyrighted materials can amount to fair use under US copyright law. So basically, fair use is a doctrine which was elaborated by US case law, which allows access and use of copyrighted contents without the copyright owner's consent, but only for purposes of research, educational or commentary purposes, so excluding any commercial use of such contents. To clear this test of fair use, many different factors are going to be considered by judges. So the first one, indeed, is the commercial versus non-commercial use. And the other one is the transformative use, meaning that the original copyrighted content must be transformed into something which is new as a final outcome.
So if I do just a copy and paste, it's not so transformative.
Of course not, yeah. And among other factors, also the fact that the final product will be competing with the original work, so basically, threatening the market of the copyright owners is going to be considered by the judges. So just based on these criteria, the District Court of Delaware, in that case, excluded the fair use against Ross. So it just found for trademark infringement, finding indeed that, of course, there was a commercial purpose purpose, because the users were required to pay to, access the legal search engine. And also, and I think that's one of the most interesting parts of the decision, they found that there was no transformative use, because although, and that's the interesting part, they weren't using directly the head nodes from Westlaw, but they were converting them into numerical data that were then used for the training. So it was kind of an intermediate copy, which is also an issue which is debated in other, AI-related cases, especially in the US. But in that case, the judges found that there was no transformative use. I mean, not enough transformation to, meet the fair use requirements.
Valentina, but this case is not in relation to generative AI, because Ross didn't use generative AI. He was using AI. And the hot topic at the moment is whether I can scrape data and then give this data to train a generative AI system, and whether I can use fair use in the US as an exemption. But in Europe, we have something, let's say, similar, the text and data mining exception. So the question to you is, if this case was happening with the generative AI system in Europe, would Ross have been able to rely on the text and data mining exemption under the copyright directive?
Well, of course, there are differences, as you were saying, between the two legal systems. And the first difference is that in the EU, we have a law about AI, whereas, as we just saw in the US, they're still relying on general copyright principles under US copyright case law. So in the EU, instead, we have both the Copyright Directive and the recently enacted AI Act, which provide for exceptions and limitations. And one of that relates to text and data mining, which is one of the most relevant and common use of such copyrighted materials for the purpose of training AI system tools. So again, under the Copyright Directive, there are specific provisions. One is Article 3, which allows the use for text and data mining of copyrighted contents, but only for scientific research purposes. So, of course, it is a very limited scope, which is restricted basically to research institute or like cultural heritage organizations. Whereas here we are talking about commercial uses. So when it comes to that, Article 4 will apply. And Article 4 is much broader as compared to Article 3, because it allows any use of copyrighted materials, so for any purposes, thus including also the commercial use. But of course, there are still requirements to be met. So the first requirement is the lawful access to the copyrighted material. And I think in that case, Ross would have had a hard time, even like before EU judges, to prove that, because as we said, it's true, it was not directly Ross which accessed the copyrighted materials, but he was first denied the license by Westlaw, so it would have been difficult to argue that that was a lawful access. The second requirement is checking whether the copyright owner did opt out. So this is a faculty that EU law provides to right holders, basically allowing them to reserve their rights over their contents and forbidding others from using that contents for text and data mining.
Yeah.
And this, of course, requires, special tools like machine-readable tools or contracts, agreements. And then we also have the third requirement, which is the limited duration of the storage of the data that are used for the training. So, of course, in that case, we don't really have equivalent, provisions in the US. So it's a bit hard to say how the case would have been decided in the EU, because we cannot really say if Westlaw did opt out, because this is not an option in the US. And also we didn't really have information about the duration of the storage of such data. But still, I think based just on the lawful access, probably the case might have turned out the same way, because, as I said, it was difficult for Ross to meet that requirement.
Yeah, that's
based on
right.
the license.
And you made a good point of having an intermediary accessing the contents, that doesn't work as an exemption for the entity using that material? Because this is a question that is so many times raised to us. If I put that middleman, it's not me who does the breach. Does it change anything?
I don't think so.
So what is the outlook for the future? I mean, you mentioned that in the US we already have cases for copyright breaches due to the scraping of contents used by generative AI. We don't have many cases in Europe. The provision in the EU AI Act is at least ambiguous. Shall we expect a position by the legislator or courts? Do you think they will take a clear stance, or we're going to have a gray period?
Well, this is all recently enacted laws, so I don't really expect the legislator to take action again very soon. So it will probably be upon the judges to interpret the existing laws. I think actually the Delaware decision might be deemed as a shift towards a more protective approach, so kind of similar to the EU one. Although, of course, the EU approach remains much stricter and rigid as compared to the flexibility that the fair use doctrine allows to US judges. But I would just say probably the AI Act even provides further obligations. And actually, one of the main purposes was indeed ensuring more transparency when it comes to the use of copyrighted contents. So, for example, now for the training, the AI developers have to provide a specific and complete report to the users about the information and all the data, including like their copyright information that they've been using for the training. So, of course, this is a first step. But I also think, as you were mentioning before, that one of the other hot topic will be the use of copyrighted content as an intermediate step, for the purposes of the training. So I think this is still something that hasn't really been addressed by EU judges, but for sure it will be one of the next ones to be decided.
Thank you, Valentina. I think your insights were very helpful. I'm really looking forward to see what's going to happen next. It's going to keep us busy for the coming years, definitely. Sure. And I hope it was useful for everyone. Thank you for listening to Diritto al Digitale. I'm your host, Giulio Coraggio, and today we had our guest, Valentina Mazza.
Thank you, Giulio, and goodbye, everyone.
See you at the next episode. Arrivederci.